Good morning, everybody. We've got a few people still hung up in the waiting room, but I guess I'll go ahead and get us started while we're waiting for them to join us. We are happy to have you here with us for our weekly Q&A, and I would like to start with my normal Zoom housekeeping reminders, which include the fact that we do request that you stay muted.
It looks like Valerie's hung up for the...
Unless you would like to... Oh, am I back?
Yes.
Hello? Okay, good. That is so weird. Okay, well, hopefully that will not happen again. I was just reminding everybody to stay muted unless you need to unmute yourself to ask a question, just to keep background noise to a minimum during our Q&A today. And I also will remind you that your Zoom toolbar is probably at the bottom of your screen, depending on what kind of device you're using. That's where you can turn your video on and off, as well as mute or unmute yourself. And I also want to remind you, as we do every week, that we are here to give general legal information, not legal advice. And it is probably the case that every single week we get some questions that are specific enough that really, whether or not that's the intent of the person who's asking the question, in order for us to really answer it specifically for you, we would have to be giving legal advice. And we just can't do that in this forum for a lot of different reasons. So I'm also going to take this opportunity to plug having an association attorney. Even when you haven't found the need for one yet, I think that is the best time to go out and find one, so that you're not doing that while you're trying to operate in crisis mode and respond to, a demand letter or something else that's urgent and of a legal nature. And establishing that relationship now means that when you have a question, do our documents allow this? Who has to pay for something after somebody's washing machine hose leaked or whatever? That it's an easy phone call or email to an existing attorney that you have a relationship with to answer those questions for you. And I think that's a benefit to every community. So if you don't have one, you should consider getting one. Also, on the same topic, if somebody tries to tell you that I asked CLG a question and they said, fill in the blank, so you have to do this thing or you can't do that thing, you can ignore them, because again, we're not giving legal advice. We're just trying to talk about these topics in a very general manner. So keeping in mind, of course, that the governing statute, right now we have 4 of those, and even more specifically, the governing documents for each community are very different. And so we can talk generally about a topic, and the answer to that particular issue in your community might be different than what we say on this Q&A because of those specific things that we're not aware of in this context. So I mentioned the chat, I think, a little bit earlier. I want to let everybody know that we will probably have time for at least a few questions from the chat today. And if you don't know where the chat is, I put a message into it a little bit ago, which maybe should make it flash on your device, just depending on what kind of device you're on again. I also, in that message, reminded you how to email us questions. If we don't get to your questions today, please send them to the info@condolaw.net email address by 4 p.m. on Monday. That gives us Tuesday to research the answers, so we are prepared to talk to you about those topics on Wednesday morning. Also, if you submit a question or you're just curious about a topic and you haven't been able to make it to the live Q&A session for a while, I included the YouTube channel link in that message in the chat, which you can follow to our YouTube channel. And then you can search by topic or just browse the most recent few videos. So you can listen in, on your drive or while you're cleaning the house or whatever, if you're not able to make it here in person. So the rest of our announcements include some things that we've been reminding you about for a little while as well, including the fact that the Corporate Transparency Act is still being challenged by National CAI on a couple of different levels. One is that CAI National submitted an amicus brief to the court with respect to that decision out of, I think it was the 11th Circuit, if I'm remembering correctly, which found that the CTA was unconstitutional. And so CAI submitted a brief in that case talking about why the CTA was essentially poorly written and should not apply to homeowners associations and condo associations. So we'll see what the outcome of that case, which is challenging the CTA in court, is. See, they are also working on efforts to just delay the implementation of the CTA by a year or two, so that the legislature can then work on writing in some more appropriate exemptions to the statute, because the statute is certainly well intended. It's intended to address money laundering and terrorist activities within that are sort of being cloaked within corporations. And so, you know, in the spirit of not throwing the baby out with the bathwater, so to speak, that would allow the legislature to more narrowly tailor the statute while, you know, as it should be, exempting corporations like community associations. So we think it's reasonable to wait a little bit longer before you start taking steps towards compliance. I was at an event recently and somebody was like, so should we just like wait until the middle of December? And I was like, I don't know if I'd wait quite that long, because the effective date is January 1st of 2025, and there are penalties for failing to comply with the reporting requirements of the CTA. I think if you want advice specific to your community about how long to wait, you should consult with your attorney. But mid-December seems a little late to me. So I would say start thinking a little bit more seriously about it if nothing has changed between now and then, you know, like in September or October. Because the end of the year is already busy enough with everything else that goes on community associations, including budgeting, and then there's the holidays and all of that stuff anyways, and adding one more thing to your plate at that time of year, I think is not necessary. So we have been talking, of course, here about the revisions to WUCIOA, and I think for a long time, everybody really focused on the WUCIOA for all portion of that bill, which of course is important, and that part does not take effect until January 1st of 2028. But there have been a number of revisions that were made to WUCIOA that are actually going to take effect tomorrow on June 6th of this year. And they are only applicable to WUCIOA communities. So if you're hearing this and you're like, what? I had no idea. What do I need to know? Unless you are or you manage a WUCIOA community, these changes are not relevant to you at this moment in time. They do include some tweaks to the statute sections about records and notice and voting. So they no longer match across all 4 statutes. We had matching statutes for like just under 2 years. And now we are going to have some differences for WUCIOA communities. Thankfully, of course, those differences will go away when WUCIOA for all takes effect. But you should just be aware that if you're a WUCIOA community, there are some changes that take effect tomorrow. Scheduling wise, I want to remind everybody that we are not doing this Q&A on Wednesday, June 19th, and we are not doing it on July 3rd. Both of those are holidays, and we are going to be closing our office, and we want you guys to be able to take that week off too, or those 2 weeks off as well. So keep that in mind. No Q&A on June 19th and on July 3rd. And the last thing that I want to remind you about announcement wise is a free webinar that Washington State Community Associations Institute is hosting on June 20th. It's a diversity, equity, inclusion, and belonging webinar. And I just put a link into the chat where you can go to register. It's free to WSCAI members, and we would love to see some of you guys join us there. That's all I have as far as announcements. So I think, Jenny, you can go ahead and take it away with question 1.
Okay, sorry, just making sure my dog decided to wander off while he's barking. So the first question for today is there any guidance on the board organizing or hosting community events? And there's nothing in statute regarding this, but just in general, make the event or whatever you're planning as widely applicable to your residents as possible. If using your association funds, make sure you have that as a line item on your budget. If owners don't want to have the event, they can reject the budget. The board isn't going to be able to please everyone. There's always going to be some that object, but as long as you spend a reasonable amount of money and it's widely applicable to your community, it's likely that there's not going to be any problems. Valerie, do you have anything to add to that?
Yeah, I'll just add what Ken had to say when we were in our prep, which was, I think, an interesting distinction, you know, an important distinction. What he said was most HOAs are not social clubs. And so if we're talking about a significant amount of money, that could be inappropriate depending on what your budget looks like, what your reserves look like, what your community, what the community sentiment is as far as that spending goes. So I think your comments, Jennifer, about including these items in the budget, calling them out specifically so owners are informed of them and can vote to reject them if they don't want them, is really important. And I think the answer to this question is different if you are a community club. Some of our common interest communities are social clubs, they're golf clubs, etc. And so the answer for those communities is really different because people buy into those communities specifically because of these types of events. So I think the answer is different based on what type of community we're talking about. I'm going to go ahead and jump into the next question. WUCIOA received a lot of criticism immediately after July 1st, 2018. Did this result in significant modifications, additions, or deletions to the Act during the ensuing 5.5 years? If so, can you summarize these and provide links to clarify the most current version, of WUCIOA now? So I'm going to start with that last question first. If you want to look at the most current version of WUCIOA, you just Google RCW 64.90, and that will take you to the current legislative website, which has WUCIOA as it exists right now, which was from the 2023 legislative session. The changes that are going into effect tomorrow have not yet been added to the legislative website. And so if you want to look at the text of Senate Bill 5796, you just Google SB 5796 Washington State, or Jennifer is being very kind in putting these links in the chat. And the bill, when you look at it, in the beginning, it'll recite all the different sections that are modified. And then as the bill goes on, each section that has been modified is essentially copied and pasted into the bill, and changes are either strike throughs if they're deleting portions of the statute, or they're called out in bold or underline. I can't remember which one. So it makes it really clear what the actual changes to the statute are. But there isn't like one easy resource where you can go to some website and it'll say like, here's everything about WUCIOA that has changed since 2018. On to the rest of the question. I don't know that I would say that WUCIOA received a lot of criticism in 2018. I think the adoption of the statute was a little bit of a surprise in terms of the timing, because the legislature had essentially failed to act on a draft of WUCIOA for a number of years at that point. And then all of a sudden we all found out that it had been voted through, and it was unexpected in terms of timing. And I do think that there was a sense of panic and an assumption that WUCIOA was going to create a lot of problems, but in reality, most of those problems never materialized. It only applied to new communities created after its effective date, except for, in the beginning, only one provision, which was the budget ratification section. And later, the Act was amended to apply the reserve study section to everybody as well. And I think most of the lawyers in our practice area agree that WUCIOA represents an improvement on the pre-existing statutes, except for maybe the Condominium Act. Honestly, in my opinion, I think it's better even than the Condominium Act, but I do think there might be sort of room for disagreement there within our practice area with respect to the Condominium Act. The HOA Act, guys, the HOA Act is like 6 pages long. So WUCIOA is a huge improvement for HOAs. And I also think it's a pretty significant improvement even for old Act condos as well. I think what you lose is minimal and what you gain is significant. As for changes to WUCIOA in the last 5.5 years, I mean, all of our statutes, all of the common interest statutes had major revisions within the last few years for things like meetings, voting, records, and notices to your ownership. That was not just WUCIOA, but those were pretty significant revisions for all of the common interest statutes. There was also changes to all of the statutes about the foreclosure process and the kinds of notices that you have to send to the owners before you can foreclose, and threshold balances due and waiting periods related to foreclosure. There were some significant revisions to WUCIOA that took place in those 5.5 years, but most of those were related to developers and so have little applicability to most of our clients and most of the folks that attend this Q&A. And the other changes were things like related to the recent heat pump legislation, which is actually, again, applicable to all of the communities. The EV charging language that was added to our statutes a couple of years ago, and then some of the more recent changes, but again, these are across the board, things like accessory dwelling units, stuff like that. So I think that I think rather than saying WUCIOA received a lot of criticism, my sort of recollection and the way I would characterize it is that everybody panicked because it was kind of a surprise when it ended up getting adopted. But in actual fact, the rollout and applicability of WUCIOA has been fairly undramatic. The one exception that I will offer is there are still communities out there today that don't know they have to ratify their budget consistent with the WUCIOA budget ratification section because they just don't know it applies to them. So I would say that's kind of one hiccup that we see, but I don't think that's a problem with WUCIOA so much as it is the challenge of when the law changes, how do you push that information out to people in small self-managed communities that are not members of WSCAI, that don't have an attorney telling them about those changes, etc. So Jen, did you have anything you wanted to add to that?
No, I think you covered it.
Okay.
So the next question is, when candidates for board positions are running unopposed, is it necessary to conduct an election? And the answer really depends on your governing documents. But more likely than not, you still need to have an election. Under 6438, for example, provides within 30 days after the termination of any period of declarant control, the unit owners shall elect a board of directors of at least 3 members, at least a majority of whom must be owners. And then 2403A 450 sub 1, except as provided in the articles or bylaws, directors of a membership corporation are elected by a plurality of the votes cast by the members entitled to vote. So there's a clear legislative intent that the community associations are governed by a board of directors elected by the ownership. Even if you only have one candidate for each position, you should still hold the election to ensure that those individuals have the approval of the association. Holding the election means the owners have the opportunity, even if they rarely exercise it, to reject a candidate, even if there's a vacant position on the board. And Ken tells the story all the time of a community that I believe it was for 5 or 6 years. This one individual was the only person on the ballot, but was not elected until people just gave up and let the person be elected. So holding an election also legitimizes the decisions made by the board and removes one argument or one issue that the owners can point to in challenging board decisions. So next part of this question, can the existing board simply appoint people to fill the upcoming vacant positions? And the answer is not unless the association did not achieve quorum at the annual meeting or an election meeting. If a vacancy occurs between the elections, the board can appoint someone to the vacant position. How long that term is depends on the language in your documents. Some say it's for the remainder of the unexpired term. Others state it's only until the next election. And one issue that we really need to point out, you can't just appoint board members to avoid elections. It would concentrate all the power of governance in the hands of a few board members, which is contrary to legislative intent. And then the last part of this question is holding an election is costly and time consuming. Is it necessary? We would say yes. Elections are the preferred way to seat a board. It is the clear legislative intent. But in the absence of quorum for the annual or election meeting, the board may appoint individuals to serve. It doesn't have to be expensive. You can get nominations before the meeting and then just they can go out in the meeting packet on the ballot. And then with the ability to conduct meetings virtually and vote by mail, time and cost involved is lower than they've ever been. And it's expensive is not a good enough reason to not follow process specified by statute and or the governing documents. Again, this is clear legislative intent that elections are held. So we would strongly recommend that you just hold the election. Valerie, do you have anything to add to that?
I would just offer that when we were talking with Ken again ahead of time, I think Ken and I, our answer to this question is yes, it is necessary to conduct an election. You have to at least try. The fact that it's a pain in the butt, that you never make quorum, that there are, not enough volunteers whatever the case might be, none of those things are sufficient to avoid what we think is the obligation to conduct elections so that your ownership has the opportunity to vote on who serves on the board. So my only thing to add would be to emphasize that I think Jennifer is being kind and less blunt perhaps than I am by nature. And my answer to this question is that yes, it's necessary. You have to hold elections pretty much no matter what. So there's a question in the chat, a follow-up question that asks what RCW allows appointing when there is no quorum. It's not so much that it allows appointing when there's no quorum, but the Nonprofit Corporations Act statutes allow for the board members to appoint a replacement in between elections, essentially. And if you don't have quorum at your election, you cannot hold an election. You can't legally do business. And so that is that's the rationale behind being able to appoint replacement directors when there's a vacancy.
Thanks,
and Katie
Katie.
put the actual site into the chat. Thanks, Katie. All right, next question. When a mortgage company forecloses on a property that the HOA has a lien on and it goes to a sheriff's sale, what happens to the HOA's lien? So I want to clarify some terminology first. 95 times out of 100, when a mortgage company or bank is foreclosing on a property, they foreclose outside of the courts using what's called a trustee sale. That's the type of auction that the lenders most often use to foreclose a property. Occasionally, usually when there's something kind of complicated going on, like maybe the owner has passed away or is, I don't know, somehow unable to be located or something, occasionally the lenders will foreclose inside of the court system. That's called a judicial foreclosure. And that's when there's a sheriff's sale, which is the auction to foreclose on the property. It's two different methods of foreclosing. Lenders in Washington state almost always do it non-judicially via a trustee's sale, but occasionally they do it in the courts. Most of the association foreclosures that are conducted are in the courts and are via a sheriff's sale, although they are generally rare. So when a mortgage company forecloses on a property that the association has a lien on, and they do it regardless of whether it's a trustee sale or a sheriff's sale, if the community is governed by the HOA Act or by the old Condominium Act and has no lien priority, the foreclosure just wipes out the whole of the association's lien. If it is a new act condominium, a WUCIOA community, or an old act condo with a lien priority amendment to their declaration, then they are entitled to recover the most recent 6 months unpaid assessments from the purchaser of the property at the foreclosure auction. So somebody stopped paying their dues a year ago, the bank foreclosed on the property today, you don't get to recover the whole of the balance due from the purchaser, but the purchaser does have to pay 6 months dues, but only, again, new act condos, WUCIOA communities, and old act condos with lien priority. So some of those benefits of WUCIOA that I was mentioning earlier, this is one of them. If you are currently a community that has no lien priority, once WUCIOA is applicable to everybody, you will benefit from lien priority. Once the foreclosure auction has taken place, the 6 months were paid by the purchaser. Let's say there's a remaining balance due. It might be 1,000, it might be 5,000, 10,000, just depending on the circumstances, right? Sometimes when a property is auctioned off in a foreclosure, the purchaser pays more to buy the property than what is owed to the bank. And in that case, the bank will deposit those surplus funds in the court registry and will send a notice out to all of the lien holders saying, we had $100,000 extra, we deposited it in the court registry, here is the case number. And lien holders, including associations, can then apply for payment from those surplus funds. And the court essentially pays those back to the lien holders in the order of their lien priority, unless they just don't apply. So if you're a junior lien holder and you file your motion for surplus funds first, and you properly give notice to all of the other lien holders and nobody objects to your motion, you could be paid out of priority, essentially, further ahead in line than you are entitled to, but that's only if you give notice, etc. If there are no surplus funds, the association can also consider whether to pursue the former owner for their remaining balance due. And how you would do that depends on the amount of the debt, the collectability of the debt, etc. So, if it's I just sent an email to a client yesterday where a property was foreclosed by the bank. It's an HOA with no lien priority, and their annual assessments are very low. So the balance due is like, I don't know, maybe it's under $1,000. And so the question for that client essentially was, how much money are you willing to spend on the legal process to try to collect only $1,000? You're going to spend more, for example, paying an attorney to file a personal lawsuit than you would be able to recover, or than the principal amount that's past due in that scenario. So one of the options might be a personal lawsuit. Sometimes boards will decide to go to small claims court when it's a small amount due, because the jurisdictional limit in small claims court for a corporation is $5,000. Sometimes boards will just write off the debt and abandon any efforts to collect it, deciding not to throw good money after bad. Sometimes the boards will refer, if it's a small debt and it's a former going that is a scenario where sending it to a collection agency might be a viable option, because you're essentially going to make a decision to write off the debt, which, by the way, is different than abandoning collection efforts. So let me make that distinction. And so sending it to a collection agency, the 40% cut that they take off of anything they collect doesn't hurt as much when you would otherwise just be sort of washing your hands of the situation anyways. So I think that covers it all. Jen, if you have any comments, you can jump in. Otherwise, you can move on to our next question.
I don't have anything to add. So the next question is, you've said in the past that an association cannot have rules that are different for tenants than homeowners. Does this mean that if an association rents out association facilities to homeowners for private events, the association must also allow homeowners' tenants to rent the facilities? If so, can the association require the tenants provide proof of event insurance? So the answer is really dependent on the particular facts and circumstances and your governing documents. So the answer might be different for a different community. But honestly, we have many clients that have different rules for tenants than owners. This particular situation hasn't been tested in the courts yet. But typically, this is not an argument that we want to make to a court that for one reason or another, the association won't allow tenants, for example, to have pets, but will allow owners to have pets. Again, it just brings up too many issues that we don't think a court would be gracious would be gracious to the association for that particular distinction. So in general, when you have a tenant in a particular unit or lot, the tenant has gets transferred the rights of the owners to use the facilities. So you probably should allow the tenants to reserve facilities. You could require the reservation to have the owner's signature or come from the owner, if that's one thing that you're wanting to double check. Also double check in your governing documents. You can assess costs of damage, costs of repair, what have you, but to tenants if to the unit if the tenant causes damage. That depends on your governing documents as well. Any requirements that you have must be reasonable. If the association requires the owners to have event insurance, especially for events where there is alcohol being served or sold, then you can require the tenants to have insurance as well. If you have a damage deposit, that can be for every reservation, not just tenants. And then you can have in the reservation agreement that any damage is assessed to the unit owner or the unit or the lot, and then it's up to the owner what to do with those charges. Valerie, did you have anything to add to that?
I would just further clarify that if you're going to have this in the reservation agreement, but it's not elsewhere in your governing documents, you're going to want to require the owner to sign that agreement, not just the tenant. So in other words, you can't create the authority to assess damages to the unit with an agreement that the owner hasn't signed. And I would like to emphasize that if you are going to require event insurance, anytime somebody rents the cabana or whatever, you should require that whether the person renting it is an owner or a tenant. Tenants can go out and they can go out and get a 1-day event insurance policy just as easily as owners can. And I think where you would run into trouble is if you only required this of tenants, but you didn't require it of owners. And I would like to also clarify that I don't think we have said you can't ever have rules for tenants that are different than for owners. But like Jennifer mentioned, the issue of having 2 different sets of rules essentially for 2 different types of resident has not been tested in the courts. And you want to be really careful so that you don't, in the way you put your rules together, essentially create 2 different classes of residents. And in particular, you want to be careful that you stay very far away from anything that might implicate or bring in issues of discrimination, FHA complaints, that kind of stuff. So as with everything, if you're considering a set of rules in this particular scenario, for sure, have the board draft them, work with the manager to do that, but have your association attorney review those rules before you adopt them, because they can point out any landmines you might be creating with those rules. I'm going to move on to our next question. I hope this is not too specific of a question, but what are the board's options when dealing with pet smells that emanate out the unit into the common areas, in addition to a trail of pet hair mixed with cat litter strewn out the unit down the hallways? One just needs to stand in the hallway the unit is located in, and you can smell the odor of cat waste. So smells, just like pet waste or smoking or anything else, can be regulated as nuisances if they are apparent outside of a unit. In other words, almost all declarations have language that says something like, no owner may engage in any activity in their unit that is noxious or offensive or creates a nuisance for other owners, right? So I think it's important for us to say that you need to check with your association attorney for your specific circumstances and enforcement ability on this. So this answer is very general, but if you're dealing with this in your community, which it sounds like you are, I would recommend you pay your attorney for 20 minutes of time to consult with you on how best to proceed before you start taking steps. And don't start taking steps just because I'm going to list them here, okay? However, in general, we recommend when dealing with any kind of enforcement issue, starting with the least aggressive approach first and only escalating when it's necessary. So the first thing I would do is ask the owner to voluntarily deal with it. Believe it or not, and I was literally just talking to my daughter about this morning in the drive on the way to school. Some people just don't notice things like this. Some people just don't notice dirt in the same way that other people do. Some people don't notice smells in the same way that other people do. And in particular, when you live in that environment, you have cats, for example, and so you're just kind of used to the smell of the pets in your home. They just might not notice. So start by asking them. I'm not assuming that you haven't asked, but I can tell you that there are many instances where a client will come and ask us for help with an enforcement issue, and they haven't even asked the owner for voluntary compliance first. So that's really important. If that doesn't work and they're unable or unwilling to address the issue, then you can sort of escalate your enforcement process further. So for example, if your association has a schedule of fines that your board has adopted and that has been published to your owners, the board can determine when a violation has occurred and can send the owner a fine notice. Make sure that your notices have been vetted by your attorney, because you have to give the owner due process. In other words, you have to tell them in the fine notice that they have the right to request a hearing before the fine is assessed. Please, please, please don't send a letter that says, you have been fined $50, but you can request a hearing if you want one. Due process happens before the fine is assessed. Telling them that they've been fined, but they can request a hearing, that's an appeal, that's a whole different thing, and it doesn't comply with the statute. If fining the owner does not resolve the issue, then you can consider more involved, but also more costly options. So, maybe this is something that you consider asking the owner to participate in a mediation about, to see if there's a resolution that everybody can agree on, keeping you out of the legal process. Maybe you ask your association attorney to write the owner a letter because maybe the owner will take that more seriously. Unfortunately, that is sometimes the case, that people will ignore the board, they will ignore the manager, but when they get a letter from a lawyer, all of a sudden they realize, oh, okay, this just got real, I got to deal with it. And then again, depending on how bad the problem is and how proactive or aggressive the association wants to be with enforcement, you could even consider filing a lawsuit to get a court order requiring the owner to address the issue, and in the alternative, allowing the association to address the issue and to assess the costs to the unit owner. So that's really expensive. I mean, you're looking at a minimum of $5,000 if you're going to file a lawsuit over this issue, maybe and likely more than that. So I would consider that very much a last resort. And certainly that's how we approach things in our practice with litigation. So Jen, if you have anything to add, please feel free.
No, I think you covered it. So the next question is, for an HOA under the HOA Act, so 6438, if the entire board resigns, can you explain if RCW 2403A535 applies? And if I'm understanding it right, does it mean that the Attorney General would appoint a professional manager to facilitate board activities that would become the cost of the association? Or is it that the Attorney General would appoint a person in the community? If the latter, what happens if no one is willing to participate? And then this individual quoted 2403A535. I'll put that in the chat in a moment. But this particular question is too specific for the forum, so you're going to need to contact your attorney. But in general, the topic of what happens when no one is willing to serve on the board has been covered recently in the past few weeks. Check the YouTube channel for that. I think it was Ken who discussed this particular question. So in general, under all the statutes, board members serve until their successor is elected or appointed. So there's never going to be a situation, or it's going to be extremely rare, that there's not going to be anyone left standing. When we were talking this morning, Ken remembered quite a few years ago, there was a case out of New York where the court found that the last board member could not resign until they had appointed other members to serve or called for an election to get members to serve. So under 6438, I believe the statute is 025. The remaining board members, even if there aren't enough to meet a board quorum, can appoint new members to the board. Excuse me. And the only way that we're aware of to get a receiver is someone, either a management company or another owner, would have to sue the association and every other owner to get the court to appoint a receiver. This is extremely expensive and typically not done. So this particular situation, the AG more likely than not would not get involved unless the corporation was a charity or one of the large associations that have a lot of assets. And typically this wouldn't happen in those associations. They'd be able to find someone to serve on the board. So if you have questions about board service or how to get members to serve, that's been covered a lot on our YouTube channel. So go ahead and search for board service or try to find some search terms that would work. But getting a receiver appointed is extremely rare and very expensive, and it doesn't happen often. So Valerie, did you have anything to add to that?
You know, I guess the one thing I would add is you want to take action early when you start viewing this as a potential problem to avoid getting to the place where there's nobody left that's willing to serve. And some of the ways that you can do this include telling your owners how expensive it will be if you end up in that last resort, worst case scenario, which would include the appointment of a receiver, right? So maybe you're a community where the board members do a lot of the work, and that's part of why nobody wants to serve on the board. Well, maybe you go out and hire a full service management company, because even though that's expensive, it's not as expensive as a general receiver running your community instead of the board. And it also means then that the management company can carry on more of the day-to-day duties, nuts and bolts of running the association, leaving the board to fulfill more of a decision-making and policy-making role, which means perhaps more people might be willing to serve since it wouldn't take as much time, right? So don't let yourself get there is essentially the short version of the answer from me, if you can avoid it. And talk to your owners about the expense of what will happen if you do let it get to that point. The next question is a short one. For a new act condo, are there any requirements in the RCWs for association funds to be held in FDIC insured accounts? So the answer to this question is that no, the new act does not require association funds to be held in an FDIC insured account. However, WUCIOA does require it. WUCIOA requires association funds to be held in what it calls a qualified financial institution. And it defines qualified financial institution as a bank, savings association, or credit union whose deposits are insured by the federal government. And so this does appear to require an FDIC insured account. And this statute is going to apply to everybody effective January 1st, 2028. So even if it's not required for your community now, it will be soon. In the interim, your board can determine how risk averse or not the community is, and can choose to invest or deposit association funds in uninsured accounts. You know, I don't know why a community would choose to do that necessarily, unless there was a particular type of account with a really significant return on investment. But in the meantime, start planning for 2028 when you will be required to have your funds in an FDIC insured account. Did you have anything to add, Jen?
No, I don't. So the next question is there any information or resources on current standards and or requirements that associations should take into consideration for replacing playground equipment? And this is a question that hasn't come up before. Thank you. So we did some research yesterday and found that there is a registry for certified playground inspectors, and that's by the National, I can't remember the actual name of the agency. It's not a governmental agency. This is a regulatory body that has it's like CAI, I believe. But if you want to have your playground inspected, you can search on the registry, and I will put that on the chat.
I just put it in the
registry.
chat.
Oh, thank you. The
Yeah.
registry is searchable by state, and there are quite a few here in Washington State. You can check municipal or county codes to see if they have any requirements listed. You can consult with your insurance company to see if they have standards. Check for reputable licensed companies that sell playground equipment. Check for installers that are bonded and insured. You can do your own research to find these companies. You can also check check the registry, and in my searching yesterday, I did find that some equipment was made by companies that were registered. So there are various ways to go about this, and there's no one central place to look. Valerie, did you have anything to add to that?
Yeah, the only other suggestion that we would make is that we do have clients that have an inspection policy for components, including their playground equipment, which of course has safety issues related to it. So you could adopt a periodic inspection schedule and create a a checklist of what someone is looking for when they're doing that inspection. And that would also have the added benefit, not just of making sure the equipment is safe, but also demonstrating that the board is exercising reasonable care in its maintenance of that equipment. All right, our next question is there's actually two questions that are related. I'm going to read both of them, and I'm going to start my answer with a caveat before I get into the response. So one question says, can the property management company during a board meeting call for executive session for the purpose of discussing how the board wants to continue to make decisions outside of regular board meetings? And the second question says, can the spouse or significant other of a board member attend executive sessions if they are not a board member? And I want to start this by saying that the question feels like it is set up to elicit a specific response, which is not what we're here to do. So I will offer comments generally about how board meetings work, how executive sessions work, which statutes apply, etc. But if someone is asking a question because they want ammunition to sort of prove that somebody else is doing something wrong, that's not what we're here for. And so that's very bluntly worded, and I certainly mean no offense to the person who submitted these questions. And I realize that it might seem offensive anyways, and so I apologize for that. But I want to be really clear that I am not going to comment on whether your board did something right or wrong by allowing somebody to attend an executive session or, discussing certain things in executive session, because that's just not what we're here for today. So all of the other statutes, the pre-existing statutes, really are silent on the issue of executive sessions. But one of the things that WUCIOA does brilliantly since 2018 is give a really clear outline of what executive session is for. And I shouldn't say all the other statutes are silent, because there's something in the HOA Act as well, but it's not quite as detailed as the WUCIOA provision. And so one thing that we've been doing since 2018, when WUCIOA took effect, is telling our clients who ask us questions about executive session that relying on the guidance of WUCIOA, even if it's not binding on your community, is a reasonable approach, and certainly would be evidence of the board exercising reasonable care in a scenario where their action in an executive session was challenged, for example. So the decision on whether to enter executive session belongs to the board, not to the manager. But that being said, many boards delegate the running of the board meeting to their manager. So just the fact that it was the manager that called for an executive session does not on its own mean that that is improper, because the board can delegate the authority to run the meeting to the manager. And if the board doesn't want to go into the executive session, the manager is not going to make them go into executive session. Okay. That being said, like I said, WUCIOA, if you look at 6490-445, I think it's subsection 2, it outlines the specific topics that are appropriate for discussion during executive session. As to whether someone who is not on the board can attend an executive session, again, I am not here to comment on this particular board and this particular spouse that was allowed to attend an executive session. But again, the purpose of executive session is to discuss matters which are supposed to be confidential for a variety of reasons: confidential bidding processes, employee-related issues, those kinds of things. Sometimes someone may attend a board meeting, may attend an executive session because they have input for the board. And in that scenario, it would be appropriate for them to, for the limited purpose of giving that input, attend the executive session. However, if it's just because, the board treasurer's spouse likes to sit in on everything and hear all the gossip or whatever, like that would probably be an improper reason to allow them to be in the room during executive session. So I realize I'm being very, very, very careful and a little bit blunt here in how I'm limiting these comments. This is general information only. I'm not saying your board did something right. I'm not saying your board did something wrong. And we cannot give you insight on that in this forum. So I think my request to you would be to sort of recognize the limitations of how we operate here and perhaps moderate your comments accordingly in the future. But hopefully at least something here has been helpful to not just the person who submitted the question, but to everybody else in trying to figure out how to handle things like executive session. So Jen, did you want to add anything before we move on?
No, I don't. So the last question that we've prepared today is, should the board make an annual decision on rolling over excess income to take advantage of IRS ruling 604, even if it is unknown at the time of the board decision, there will be excess income. So the vote is actually by the membership, not just the board. It must be a vote by the association to roll over funds. If this is an open meeting, if this is an option the board would like to have, then you can just add the vote to the budget meeting or the annual meeting. You don't have to know whether or not there's going to be excess funds to roll over when you take the vote. So it just allows the board that option to roll over excess funds and potentially reduce assessments for the next year or add it to reserves. If the owners have approved it, the board can do it. Valerie, did you have anything to add to that?
Nope, I think you covered it. So we have some questions from the chat. The first one says, how much money or percentage should an association set aside for attorney's fees? And, you know, I'll start with this one and just say that there's really no way for us to answer this question because it's going to vary wildly based on the size of your community, maybe the location of your community, the age of your community, the types of legal issues that you might be dealing with. So the answer is going to be one thing for a, 10 home HOA, single family home HOA, and it's going to be another thing for a 300 unit condo and another one for a 3,000 home master association with 20 sub associations in it, right? I think there are ways you can figure this out. And one thing that I would suggest that you do is look back at your last 2 or 3 fiscal years and determine how much money your community spent on legal fees during those years. And then look at whether there was anything unusual going on in any one of those years. So if one year you had litigation happening, but you don't anticipate that this year, perhaps you can budget less than what you spent in that litigation year. I would also recommend, in particular right now, as we are looking down the road at this WUCIOA for all effective date of January 1st, 2028, a lot of communities are choosing to be super proactive and start budgeting right now to restate their governing documents. It is not a requirement of the statute, but a lot of folks are just deciding they don't want to deal with the confusion that might be created by the statute saying one thing and their documents saying another. And so they're already planning to do restatements to bring their documents in line with the statute. If that's something that your community might like to consider, and in particular, again, the older your community is, the more likely it is that your documents need work. Also, again, the most significant changes are going to be for folks that were governed by the HOA Act that will now be governed by WUCIOA. That's something that you could consider budgeting for as well. And it doesn't have to all happen in one year. So you reach out to your association attorney, find out what the approximate cost of a restated declaration and bylaws is going to be, and then split that up over 3 years so that you spend the money in 2027 and your documents are ready for 2028. We have clients that are doing those documents right now. I'm not saying that a delay is recommended. I think if you wanted to go out and restate your documents right now to be consistent with WUCIOA, that's also a great option if you have it, if you have the money in your budget to provide room for that. So again, I think this question is just way too broad for us to be able to answer definitively for any community. There is no percentage of your overall budget because legal fees are not a percentage of anything. They're based on your actual legal needs in any given year, including things like, do you need an attorney to help you record liens or assist with any delinquencies? Do you need to redo any of your governing documents? Do you have a really large project coming up where you should have your attorney review the $200,000 contract with your contractor? So it's really specific to what you have going on and not a function of your budget as a community. Jen, did you have anything you wanted to add on that?
Just briefly, we all the time get questions from small self-managed associations. We have this particular issue. What can we do? And they typically don't have a budget for legal fees or have a very minimal budget. And then suddenly they're looking at a special assessment or having to rearrange costs. So having a line item in your budget for legal fees, even if it's not used, is probably a good idea. Yeah. Because you never know when there's going to be a situation where you need legal advice.
Yeah, I would agree with that completely. You better to plan for it and not need it than the other way around. All right, next question from the chat. If time permits, assuming the governing documents are silent to the creation of a finance committee, are you aware of any communities where the finance committee is an independent entity which provides oversight of the board? I'm going to take a stab at that and say no. And in particular, because the board is the group that is charged with the governance of the association. They are the decision-making and policy-making group within the association by statute. They are vested with the authority to do that on behalf of the association. So the wording that says oversight, that sort of would imply that the finance committee would have authority over the board. And that's not how the statutes are written. That being said, I think having advisory committees is certainly contemplated by the statutes. We have many clients that have advisory committees on any number of issues, including things like finances, governing document rewrites, community building, social committee, you name it, there's a committee out there for it. Generally, they are advisory. Sometimes they do have decision-making authority, but then you have to comply with the statutory requirements about how many board members have to participate in those committees in order for them to exercise the decision-making authority of the board. But none of them would have oversight authority over the board, in my opinion. Jennifer, did you have anything to add to that?
Just briefly, as Valerie said, statute, and this is for all statutes, this applies to everyone, no matter when you were formed. The association acts by and through the board of directors. Now, the board can delegate authority to a committee, but how that's done and the number of board members and how voting is done is set by statute. So in very, very, very few cases should a board delegate all financial authority to a committee. So there's no committee that has oversight of the board. The entire association oversees the board. So if you have a problem with particular board members, you can ask for a recall. But the board is the decision maker. They're the ones that basically represent the association.
Thank you, Jen. All right, next question. The board forms a landscape committee. There are no board members on the committee. The board approves the annual budget, which includes funds for a landscape contractor and additional funds for landscaping. The governing documents do not allow committees that don't have a board member to exercise the authority of the board. Is the committee allowed to spend the additional funds without board approval, even if money has been allocated in the budget? Okay, number one, that's too specific. You're asking us to give advice on a specific situation, which we can't do. And actually, I'm not going to even go on with the number two. That question is too specific, and it would require us to comment on a specific scenario that we do not have all the facts and the information about. The thing that I can say generally is that if your board approves a budget and it is properly ratified by the community, then the funds can be spent as they are allocated. But I'm not willing to comment any further about this particular scenario because I just think it's too specific. Do you have any thoughts to add to that one, Jen?
No, I think we covered committee authority and how committees are done.
Yeah.
Just a few moments ago.
Okay.
There is a quick question that I saw in the chat. Where is it documented that dual authorization is required for reserve transactions? A board member wanted to move reserve funds to a high rate savings account, but it only takes one person to make transactions. So the statutes that have provisions regarding reserve accounts are the new act, WUCIOA. Double check in there. I believe the statute does state that it does require a dual signature, but most banks don't even double check to make sure a check is signed. So although statute requires it, banks don't. So moving money around typically just requires board authorization and meeting minutes. And then the treasurer, whomever has authority over those accounts, can move the funds. Valerie, did you have anything to add?
Yeah, I will offer as a practical or instructive anecdote that I think it's a really good idea to have two signers on any account controlled by the board for a variety of reasons. One, of course, is oversight and fraud prevention. But the other is I just had a conversation with somebody in a client community where their board treasurer died very suddenly and unexpectedly. And they were really lucky because the board president was also a signer on the account. Had they not been, what they would have had to do to access those funds was probably file a lawsuit and get a court order authorizing or directing the bank to release the funds to the association and add new signers on the account. So as a practical matter, even if there isn't a statute that specifically says it, I'd have to look at the reserve account statutes to see. I know that they do require the accounts to be under the direct control of the board, but I can't remember if the statutes themselves actually specify the requirement of two signatures. But if you don't have two signers on the accounts, you're just playing some kind of roulette there that I just don't think is worth the risk. So and that's happened. I've encountered that scenario with clients twice in the last, I don't know, 3 years maybe. So it's not like it's super uncommon either. With that, we are at 11:01. So sorry we kept you a little bit late. Thank you all so much for joining us, and we will see you back here next week. Bye, everybody.